Hi, good afternoon. Today is Thursday, June 16th. My name is Ashley Glover, and I'm here with attorney Eric Einhart. And we are happy to welcome you to our webinar, Guardianship, Decision Making for Those Who Lack Capacity. Thank you for joining us. Before we start, I do have a few quick housekeeping notes. Your mics are muted. You'll want to use the Q&A box to submit questions. We do have some time reserved at the end to answer as many as we can. This presentation is a half hour. We are recording and we'll email you a link to the recording. Let us know how we did in the survey. And if you need to message me about anything, please do so using the chat box. All right, so who is Eric Einhart? Eric is a dedicated partner of the firm. He practices in estate planning, elder law, estate admin, and I say with full confidence that he is the subject master on guardianship. He's the head of the guardianship department, and he leads us with 10 years of experience. And Eric, it looks like you've added something fun on the slide. If you scan the QR code, or go to the firm's website, you can learn more about Eric. And whoever emails us first after the webinar with the correct answer wins a cup of Joe on Eric. I'll send my email through the chat. But the question is, what's the name of Eric's dog? All right. Eric, this would be much of a program without you. So Thank you for putting this together.
Thank you so much, Ashley, for the lovely introduction. I always feel like I need to give you a tip afterwards because you're so nice about.
I do accept cash.
What about Venmo? So take a look at the firm bio and let me know what my dog's name is. So welcome everybody, and thank you so much for coming today. What we're going to cover is we're going to talk about how decisions are made for an individual who needs help, who lacks capacity or has some functional limitations. We're going to talk about different types of financial decision-making, healthcare decision-making, and kind of going to give you an overview of guardianships in New York State. So when I think about how are decisions made for an individual who needs help, the first thing I want to think about, so I have a client who comes in or someone I'm talking to at a cocktail party or something who says, you know, I have this spouse or this uncle or this parent or this grandparent who needs a guardianship. They can't make decisions for themselves. The first thing I want to do is just kind of take a pause and think about the person's capacity. So they may be eccentric in their decision making. They may have some issues that you believe would allow them to not make the decisions or prevent them from making decisions. But legal capacity is something that's important to have an understanding of before you jump the gun and move into a guardianship proceeding or try to take over things in their life, whether it's healthcare decision or financial decision making. So we want to think about capacity. Adults are presumed to have capacity, and if they don't, then they may need assistance, like through advanced directives or guardianship. But also, people have moments of lucidity. So even if they have a diagnosis of dementia, they may have a moment where they're clear-minded and they understand what's going on. So we don't want to jump the gun, and we always want to meet with this person and have a understanding if they do have capacity or if there is a potential for them to have capacity to execute documents that may need to be executed or to make decisions for themselves, right? So the first thing after you consider the capacity question is, do they have legal documents in place that would appoint an agent or agents to make decisions for them? And these are called advanced directives. And we'll discuss a little bit more about them in a bit. But these legal documents, if they are done during the time when this individual had capacity, those could be a lifesaver, and they could allow someone who they have appointed previously to step in and make decisions, whether it's financial or medical, for this individual who may have some issues and need some help. If they don't have advanced directives and they do not have capacity to manage their affairs, you're going to want to think about some creative avenues to take care of them, before you move into a guardianship or during that process. So for instance, if they're in a hospital setting, there's something called the Family Healthcare Decisions Making Act, which we'll discuss a little bit more in greater detail in this webinar, but that's allows them to have a surrogate get appointed in the hospital setting or a nursing facility setting to make medical decisions for them. So you don't necessarily need to have a guardian appointed or a healthcare proxy in that exact setting. There are some significant limitations to this, so it's always best to have a healthcare proxy appointed, or if you don't have a healthcare proxy and the person cannot execute one, you definitely will need to move forward with the guardianship. But this may be helpful on a temporary basis. Also, is there an opportunity to access funds for this person to help pay for their immediate expenses? So for instance, am I a joint owner on my spouse's bank account? Yeah, I can probably access our money and make the payments for us as a family. Or if I'm a joint owner on my parents' bank account, will that allow me to access resources to help pay for their costs of their care in an immediate situation? That might be very helpful. So you want to think about just different creative opportunities to help this person while pursuing a more permanent solution, right? So the permanent solution, if the person lacks capacity, they don't have advanced directives, and they cannot execute advanced directives now, is a guardianship, which we'll discuss a little bit more in a second. Ashley, thank you. All right, so if the person has capacity, I would certainly suggest that you run, not walk, to our office to have them discuss the concept of advanced directives. And these are legal documents that a principal would put into place that appoints different people or provides instructions to manage their affairs in the event they lose capacity in the future. So the first off is a power of attorney. So not every power of attorney is created equal. I suggest to all my clients to have a comprehensive, durable power of attorney. And I also want them to have the latest and the greatest to make sure that if they have one that's executed previously, they should execute the most recent version of the durable power of attorney statute. This is a document where a principal will name an agent or co-agents or successor agents to manage their finances and legal affairs. This could be very broad in authority that you're giving to your agent or agents. And we generally suggest that it should be broad because you're planning for the what ifs and the who knows in the future. So this document will allow them to do anything from handling day-to-day banking to picking up mail at the post office, selling real property, petitioning for government benefits, things like that. So it's really handling your legal and your financial affairs. And this is in effect when you sign it, even if you do have capacity and it survives your lack of capacity. So if in the future you lose mental capacity, this document survives and your agent continues to manage your affairs. It is revocable and it will expire upon your passing if you were the one who executed the power of attorney. A healthcare proxy is a document whereby you as the principal are appointing an agent to step into your place to make decisions regarding your routine or major medical decisions in the event that you are unable to understand or communicate your medical decisions. This healthcare proxy, this agent is supposed to act as your surrogate, so they're not acting in a way that or making a decision that they think is the right move. It's really a decision that you've communicated with them previously. So we generally suggest to our clients to say, kind of joke around with them. I'll say, talk to your healthcare agents and your successor agents, bring them out to a nice dinner and explain to them all the medical decisions you want to be made in the future, if you could think of them. So what treatments you would never want, what treatments you feel comfortable with, things like that. You want to have that conversation. This way, that'll allow the agent to make a decision that they know you would have wanted to make, and they're not just making a judgment call on their own, right? So the next document is a living will. This is a document that provides evidence of your end-of-life care wishes. It doesn't necessarily appoint somebody. It just explains that you would like to be, either have life-sustaining treatment like artificial ventilation, hydration, nutrition, withheld or removed if upon the concurrence of two attending physicians, you're in a permanent vegetative state and your situation is terminal. So this allows your family or your agent and your healthcare proxy to communicate your end of life care wishes and to have them honored by a facility. A HIPAA authorization is a document whereby you're providing representatives or naming representatives that can communicate directly with physicians or anybody in a hospital or medical setting about your medical history and your medical records. So they can access your medical records and communicate your medical history and information. So these are really important documents to have, especially if you have capacity now and you're doing well and you want to just plan for the future. This is super important. I recommend anybody who's, between the ages of 18 and 118 have these documents because it's going to really help avoid the potential for a guardianship proceeding if you lose capacity in the future. So, strike while the iron's hot and you have capacity and get these documents executed. And if you know somebody who you're concerned about their capacity, or you're just concerned about them in general, they should reach out to us and we should talk about having these documents executed because it's going to be a lifesaver in the future. All right, next slide. So what if you don't have these documents and the person that you're helping, the person you're helping doesn't have these documents and they don't have the capacity to execute them anymore and they're in a hospital setting? This is where the Family Healthcare Decisions Act comes into play that we talked about just a few minutes ago. And this statute is really only applicable for patients in a hospital or in a nursing facility or in a hospice setting. And what it does is upon the determination of their incapacitation, it'll allow a surrogate to step in and make a decision for their health care, right? So there is a hierarchy of who can be appointed or who can be named to this role. And the hierarchy is as follows. It's a guardian appointed under Article 81 guardianship proceeding, a spouse, if not legally separated, that's important, or a domestic partner, an adult son or daughter, a parent, a brother or sister, and then it gets more attenuated relationships like a close friend. So you may not want somebody in this exact priority or this order to be appointed to make your medical decisions. So it's really important that you don't rely on the statutory default in that situation. Wherever you really need to have a healthcare proxy established as soon as you can. But if you don't, this is what happens in a hospital or a hospice or a nursing home setting. And these are the people who can help make those decisions for you. So next slide. So what kind of authority does a surrogate have once it's determined that you don't have capacity and that you don't have a healthcare proxy and that you don't have a guardian? Well, your surrogate has the right to access medical information and the records necessary to make a decision. They can't just get all your records just because they want to be nosy. It has to be related to the decision that they're making. They have the authority to make a routine or major medical decision for you. And if a doctor determines that you've regained capacity, all bets are off and their decision-making capabilities are no longer available. So when you're making a decision for someone in this situation, you want to abide by their wishes, including any religious or moral beliefs that they may have expressed to you or expressed to others. And if their wishes are not known, you always have to act in their best interest. That's important. Not your best interest, or if you feel guilty or something, making a decision always in their best interest. Okay. So what happens if you don't have capacity and you don't have the legal documents like advance directives, and you don't want to put a Band-Aid on a bullet hole and rely upon the statutory defaults, which I do not suggest? Well, then at that point, a guardianship is going to become necessary. And in New York State, there are 3 different types of guardianships. There is the Mental Hygiene Law Article 81 guardianship. This is for adults who have functional limitations. They once had capacity, but now as a result of either a traumatic event or a chronic illness, they no longer have capacity or they have significant functional limitations. In Article 17A guardianship, the Surrogates Court Procedure Act, Article 81 Surrogates Court Procedure Act, Article 17A guardianship. This is a guardianship for adults with developmental and/or intellectual disabilities. And this is taken care of in the Surrogates Court of each county. And it is based off of medical evidence and the best interest of the the individual. And Article 17 is a Surrogates Court Procedure Act, Article 17 proceeding. This is, again, a guardianship in the Surrogates Court. It is not for adults. This is for minors. So that's the big distinction between the 81 and the 17A. Article 17 proceeding is just for a minor. It could be for their personal management or their financial. So although there's 3 different types of guardianships, we're going to focus on the Mental Hygiene Law Article 81 guardianship in this webinar. So Article 81 guardianship is handled in Supreme Court, which is important because there's many different types of many different judges available in the Supreme Court, and the Surrogates Court is really just one in each county, unless your county is 2. But generally speaking, it's more judges that are available to handle these cases. The person that is the subject of the Article 81 guardianship proceeding is called the alleged incapacitated person, or the AIP. And again, this is for an adult who has functional limitations. You are not going to enter medical evidence into the record if you're the petitioner, unless the AIP enters it first to prove that they don't need a guardianship. So this is really going to be based off of testimony and observations of the individual's functional limitations. It could be a guardian of the person and or the property appointed. And this is a guardianship that is the least restrictive means. So the idea here is to only have the guardian have the authorities that the guardian absolutely needs in that moment. And if there's further, need in the future, then you go back to the court and you ask for more powers. But the guardianship really should be tailor fit to meet the actual needs of the person. So if they have the ability to make medical decisions for themselves, but they're really not great with finances, and they're apt to or getting defrauded or something, you're going to want to pursue a guardian of the property, but maybe not necessarily the guardian of the person, and vice versa. So if they're good with their property and they may not be great with making decisions for their health and well-being, you're going to pursue the person, right? So it could be either or it could be both. Again, it's not based on medical evidence, and you want to have a tailor-fit authorities you're giving to your guardian. This can be a real onerous, time-consuming, emotionally draining, and expensive process. And it is oftentimes an absolute necessity, and you got to move forward with it because the person needs help and they don't have the legal structure in place with the advanced directives. But if there is an opportunity to avoid this kind of guardianship, I would absolutely pursue that option first before we jump into this guardianship proceeding. It's going to be expensive for the petitioner. It could be expensive for the AIP. It could be very time consuming, takes a couple months to process this. It is an opportunity for litigation, and it can be devastating to the individual, the AIP, and their family. Also, it is emotionally draining because you're going to be potentially on the stand explaining the deficiencies that person that you love and care about has in open court, and that's not really an easy thing to do. So I caution people to just be mindful of that before they jump into an Article 81. It is absolutely necessary and can be incredibly helpful in a lot of cases, but it's not something you want to just jump into without really having your eyes wide open, right? So how do you become a guardian? Oh, that's good. Thanks, Ashley. How do you become a guardian? So first, you really should obtain legal counsel. And I know that sounds very self-serving, but it is a challenging process, and it is naturally an opportunity for litigation. So you really should have an attorney who knows what they're doing to help you with this situation or help you with the process. Once you've obtained competent legal counsel, you're going to petition the court and explain what the circumstances are, why the need for the guardianship is there, what authorities you're requesting, and why you need those authorities. And you're likely going to nominate a particular guardian. So for instance, if you're the petitioner and you think that you should be the guardian, or someone else that's in this person's life that could be helpful, you're going to want to suggest that to the court. If you don't have a nomination, whether you don't think you're up for the challenge, or it's you're just not fit for doing that, that's fine. You would just ask the court to appoint somebody that they feel is appropriate. So you're going to petition the court. The court's going to issue an order to show cause And this order to show cause is going to explain that there is a guardianship proceeding. It's going to explain the powers that you're asking for. It's going to appoint a court evaluator, and it's going to potentially appoint a court-appointed attorney for the alleged incapacitated person, the AIP. And it's going to be served on all the interested parties, especially the AIP. And it's really kind of like this big, bold document that says, caution, this is what's happening. And it is intended to provide notice to the interested parties that something significant is happening, and this is an important proceeding, and you should pay attention to it. So once you go through the process of serving everybody with the order to show cause, the court evaluator who's appointed by the judge, that person is going to be the eyes and the ears for the court, and they're going to be responsible for going out into the community, meeting with the alleged incapacitated person, meeting with the petitioners, meeting with the interested parties, explaining the process, gathering information about what's really going on, and then reporting back to the court with a written report and with oral testimony at the hearing. After you go through the hearing process, if you're appointed, or the court determines that there's a need for a guardian and one is appointed, that's when, kind of the real fun begins, because it's a process to get appointed. But once you're appointed, your job's not done. You got a lot more to do. Okay, so there are significant benefits to being a guardian. And a lot of times it's not just, hey, this is a great benefit. This is a necessity, right? So a guardian could be appointed with the powers to help manage financial affairs, immediately access resources for the person to pay for their care needs or the living needs, can handle lawsuits for the person. They could petition for, apply for government benefits, help do Medicaid planning in order to allow the person to become qualified for government benefits like Medicaid. They can handle all kinds of business dealings for the individual if they're given the proper authority. So property management powers are real significant, and they can be very robust, or they can be very limited in scope if the person has the ability to handle other things on their own. Also, for personal needs, this could be a situation where you could have the power to make major medical decisions, dental decisions, make sure the person is in a safe place to live, dictate their social surroundings, meaning, make sure that other people who are bad influences on them or bad for them are not in their nexus. A lot of times you have situations where someone is being abused by a caregiver or a family member or just someone in the community. You want to cut that person out of their life to make sure that they're safe. So these are all different benefits that a guardianship can provide to the alleged incapacitated person. So as I mentioned before, once you actually get appointed, that's when the real fun, joking around begins. Once you're appointed as a guardian, the judge is going to issue an order and judgment, and you're going to need to get a commission based off of that order and judgment. Your authority as the guardian doesn't begin until you actually have the commission that's issued by the county clerk's office. So, it's the hearing, and then it's the order and judgment, then it's commission, then you can actually handle certain affairs for the individual. You're going to have to file an initial report within 90 days of being appointed as a guardian. You're going to have to file an annual report every year, and it accounts for your actions as a guardian. If you have any special requests, like further powers you're going to need, or any oddball scenarios you need to address with the court, you have to make a special request to the court. If you need to resign, or if the guardian passes away, there's a whole proceeding to have a successor, a standby guardian appointed. And if the person either regains capacity or they've passed away, you're going to need to petition the court to terminate the guardianship. So your obligations to the court extend beyond being appointed. It's pretty significant. So it's something you want to be mindful of before you jump into that role. Next slide. So a couple things that is generally speaking in our practice that we see when there is a need for a guardianship. Oftentimes there is it coincides with the need for long-term care, and with long-term care comes a significant expense, and Medicaid planning is often an ideal situation in order to help the individual become eligible for Medicaid, in order to have Medicaid cover the cost of long-term care. So this is something that we regularly do for clients who are either in the process of petitioning the court to become the guardian, and we address the Medicaid planning right up front with the court so that they can hit the ground running and make sure this person is eligible for Medicaid as soon as possible and can get on Medicaid. Or if there's already a guardian in place, and then maybe they don't have the authorities necessary to help this person become eligible for Medicaid, and there's a need for that, we would jump in and make an application to the court to help them do some Medicaid planning. Next slide. Also, we live in a very mobile society. People are moving from in and out of New York all the time. And there's a guardianship in New York. You can't necessarily, move to the next state, move to Jersey, or move to Connecticut or Florida or wherever, and have that guardianship come with you. There's a process to transfer guardianship of an individual if you're moving that individual out of state, or if you're moving that person to New York. And it's kind of a onerous process, but it's something that we do regularly for clients, and we can help you with. So if you're moving a person with a guardianship from another state to New York, or if you're moving a person with a guardianship from New York to another state, we can assist you in that process, and it is kind of a challenging one. Next slide. Another big situation that comes up, but we see a lot, is the sale of real estate that the person owns. So if I'm an incapacitated person, and because of my incapacity now, I need to be in a skilled nursing facility or an assisted living facility, and I have a home that is kind of just sitting there and costing money. A lot of times the guardian may say, you know what, it's in the best interest of my alleged incapacitated person to sell this property and to use the sales proceeds to cover the cost of their care. That is a whole process in and of itself, just to sell real estate when there's a guardian appointed. You have to petition the court to even consider the option. The court's going to appoint a real estate broker. Unless you've requested one specifically, they're going to pull it from a list. The court's going to have to review the contract of sale. They're going to let it be open to open bidding, see if someone can come up with a higher bid, a significantly higher bid usually. And then you go through the process of the transaction, and then you got to go back to the court and explain what happened and get them to bless the transaction after it occurred. So it is a process that has to go through if you need to sell real estate, and we can help you with that as well. Next slide. So in summary, there are a couple different ways decisions are made for an individual who needs help. Guardianship is an important one, but it should be the last resort. You want to consider different options to making financial decisions, different options to making healthcare decisions, and then I would pursue the option of a guardianship. So I guess let's open it up to questions.
All right, Eric, I don't see any questions just yet, so let me move to the next slide. And if we get something, then we can answer it.
I bet everybody's on the website trying to find out the name of my dog. That's my guess.
I can't wait for the responses. What makes Russo Law Group different? It's our dedication to our clients, our scope of legal services, and the level of experience. We will not learn at your expense. Here is a list of the services that we provide and how we can help you and your family. I would urge anyone who has further questions to give us a call. We're happy to speak with you after the webinar. We do appreciate everyone for joining us. Please leave us your feedback in the post-webinar survey. It will pop up on your screen as soon as we close this out. I know Eric and I look forward to skimming through those at the end of this, so I appreciate your responses. All right, I don't see any questions, so you must have done a heck of a job.
So if anybody has any questions and they haven't asked them now, please feel free to give us a call or shoot us an email. And absolutely, you should schedule an appointment to meet with us if you have any further questions or need some assistance with advanced directives or potentially a guardianship.
We did just get one. Eric,
if your person is getting Social Security, when is a good time to decide if getting Social Security is better than a pension or Social Security? So I don't know, I don't quite understand the question. If they're getting Social Security, I'm not sure how you determine it's time to get Social Security. You know what, why don't you reach out to us, and we can expand upon that question? That might make more
Yes.
sense.
And also, Miss Gray started to type something, but it looks like the chat was cut off. If you guys want to just email me, I did send my email address. I did send my email address through the chat box. It's aglover@vjrussolaw.com. Just email it and Eric and I will get together and get a response for you. All right,
But
but
the
that,
question looks like it's regarding what if you're intellectual and developmental adults? That is going to be handled through a Circuits Court Procedure Act, Article 17A guardianship. And is it possible to reverse a guardianship? Yes, if the person regains capacity, it is possible to reverse the guardianship or terminate the guardianship. You have to petition the court. Okay,
okay. All
thanks,
right.
everybody.
Well, yeah, we've reached our time. Everybody take care. Thank you for joining. Eric, you're awesome. And we'll see you all next time.
Bye.
Bye.